The subcommittee will reconvene, and at this time, I'm pleased to recognize the gentlelady from California, Ms. Eshu, for her questions, and she's recognized for 5 minutes.
Thank you, Mr. Chairman, for continuing this important hearing, and I do support having more on this because I think there's work for the committee to do. I want to thank the witnesses for your testimony today. And first I want to start out with a few observations and then ask a couple of questions. I'll go as quickly as possible because we only have 5 minutes. In my opening statement, I thought it was important to acknowledge that, that ICANN as an organization has had several noteworthy accomplishments. And I mentioned some of those. And so I want to be fair in acknowledging that. That's one side of the ledger. And it's an important side. And I salute you for the accomplishments that you've achieved. On the other side of the page, I think that there's some work to be done. I think that to allow the spinning off of ICANN at the end of this time frame is not the right way to go. And I just don't. I hope that the committee comes to the same conclusion. What's troubling to me are the following things. First of all, it's with much curiosity to me that as the United States of America is the mother, the father of the internet, and that its ultimate trademark, so to speak, imprimatur, is that it is open. And we have had many debates, many fights to define what's open, how to keep it open, because it is democratizing, it is all of these things and so much more. And yet it seems to me from some of the testimony today that the way ICANN operates does not match that. And I don't think that's healthy, and I don't think it really promotes what the internet is about. If ICANN were spun off, how do we guarantee an open future relative to the internet? Who would? Who would they be accountable to? How do we have any kind of say-so in this? I know that Iran, Cuba, China are interested. They'd love to take it over. And hey, God bless them. They've got good taste. They know something good when they see it. But I am troubled by the lack of accountability. I believe that we need to be thinking about a new set of rules that would be part of the agreement and in the JPA. It's my understanding, Mr. Twomey, that in 2003 that there were public members and they were voted off the board. Is that correct or is it incorrect?
There was a round of board members who were elected worldwide. It was much earlier than that. It was in 1999, 2000. I
don't know what you're saying. Were they public members or just regular members and then they rotated off the board?
These were board members. The board
are there any public members?
There is members, if you mean consumer members representing consumers, yes, there are.
And who are they? And how many are there?
There's one member on the board now, Wendy Salzer, and she's a member of the board, and we are looking at potentially looking at increasing those numbers.
Looking at increasing. So one out of how many?
Well, that's out of 21.
That's a pretty lousy ratio, if I might say so myself.
But I would say that the same group helped select nearly half of the board members in terms of our nominating committee. So the same group of people, the same consumer voices are involved in that.
Well, I think I've gotten my answer. It's not very good. Let me ask you this, Dr. Twomey. What are the specific problems that you're trying to address by seeking complete independence from the Commerce Department? In other words, what breakdowns have occurred? Why do you want to break? What are you going to go off and do It seems to me that the Commerce Department and NTIA have a very loose affiliation with you. I mean, this is not a heavy hand, and I'm not suggesting it should be. But what do you want to accomplish by spinning off? What's in your way now? What's in the way?
Congresswoman, I'll be very clear. We're not looking for independence. I mean,
what are you looking for then?
We're looking for the continuation of the model.
Do you want the JPA? You want to continue in it?
We think the JPA should come to its conclusion because...
What does that mean? You want to come to a conclusion. What does that mean? It comes to an end and there isn't any JPA anymore?
What we think is we should move away from these sort of temporary documents. The JPA at the moment is a 2-page document. 2 pages.
Well, why is it so menacing to you?
And so what we're actually suggesting is that we should actually put in place some of the principles that the members of the committee think are important. We should put them in some more permanent statement at the end of the JPA.
You know what I think this is, and I hope I'm wrong, but this is the impression that I'm getting, is that there is disdain for any U.S. authority in this. And while we have to have very strong partners throughout the world, our role can't be and should not be, in my view, leapfrogged over. Is that...
That's not the intention at all.
It's not the intention?
Not at all.
Is there any sensibility around that, or is it totally false?
There is a balance, right, in this broad debate of how to have an organisation that is accountable to the United States in the way you're putting forward, and at the same time engages all the country code operators of the world, all the governments who are in our government committee, all of the people who help make the system work, and so. We're not looking.
Well, I don't know whether you've told us what the problem with the JPA arrangement is, which is a mystery to me that you want out of it. But it seems to me, Mr. Twomey, that you've been saying to us that stakeholders want to be independent, and we have stakeholders that are testifying that are saying absolutely not. So there's a division of approach here. And that's why I think we have some more work to do on it. And I hope that what we can count on when we get to a rewrite or an extension of the JPA is that we get some very good ideas from stakeholders, suggestions about some of the rules of the road. I don't pretend to know what all of them might be, but it seems to me that we've got some experts here today and plenty of others, but I really do not believe that this thing should just be spun off. I don't think, A, it's necessary, B, we're putting on my hat, and I know I'm going over time, but I think I'm the only other one here, as a member of the House Intelligence Committee, how important the Internet is to our country, in our national security, and the role that it plays. And so I think just allowing ICANN to go off, to spin off, to become I don't know what, is deeply concerning to me when I put that hat on. So I want to thank all of you, and I look forward to working some more on this, Mr. Chairman, and I appreciate the extra time and your patience.
Thank you very much, Ms. Eshoo. I'm going to ask unanimous consent at this point to insert 3 statements in the record that have been submitted to the subcommittee commenting on the general subject matter before us today. These have been reviewed by the minority. Without objection, these will be inserted in the record. Mr. Stearns and I both have some additional questions we would like to propound, and so we're going to open a second round of questioning for such members of the subcommittee as desire to propound additional questions. And Mr. Twomey, let me continue the questioning of you and return to the subject of the proposal that you have to issue additional top-level domains. What assurance do you have and can we take that if additional top-level domains are authorized, that real competition will emerge in the bidding for these domains? Have you taken any kind of survey of potential bidders? As a related question, will you have any kind of bar on existing registrars being able to bid for these domains? In other words, registrars who currently administer other top-level domains? And what other assurances can you put in place that there will be real competition in the event that that new top levels are authorized?
Well, thank you, Chairman. From all the feedback we have received in the process, which has been going, this discussion of new gTLDs has been going for 10 years. The policy process took 5 years with all the stakeholders involved. We're now going through this how do you implement 18-month discussion. In that process, it's been clear to us that there's a range of people who are very interested in applying. Some are in pretty general terms. They're looking for general terms in English, shops and .webs, that sort of thing. Quite a lot of people interested in geographic terms, as I mentioned before, some of those cities, Berlin, New York City, Paris. Interest from indigenous communities. There's some talk about potentially a .Maori or a .Sami, so people looking to represent that. There's clearly interest from some companies for brand names, and you wouldn't be surprised, Chairman, to know that companies are not monolithic. So we get, not only when we hear from intellectual property lawyers inside the companies of concern, we also hear from their marketing departments and their product development departments that they're really interested in having a top-level domain. So we're hearing that difference. And I think the other area...
You've talked about areas where you might have one bidder. If it's an indigenous tribe, for example, potentially you'd have that tribe bidding to operate or someone associated with it. I don't know. But do you think you'd have real competition in the bidding for such a top-level domain? Would you have a variety of bidders seeking?
The process would be fully open. So if other bidders wish to bid...
Well, I understand the process would be open, but to what extent do you have confidence that there would be real competition in the bidding through that open process?
We are trying to make the process as open, as transparent, and as even.
Well, you're answering my question with a process answer, and I'm really asking a more fundamental question. It's almost an empirical question. Have you actually done a survey and identified within these various TLDs that you might issue more than one bidder or any bidders for some of them?
We are expecting for some of them there will be multiple bidders. It's been quite clear for some that people have made clear that there would be multiple bidders. And we
would you demand that assurance that there will be multiple bidders before you would authorize a particular new top-level domain?
The policy process to date is not prescriptive on that, because we would think there'd be institutions where people would like to have a top-level domain. For instance, if it was a company brand name, where that company itself would want to have the brand and not want to have to bid to another person. I mean, that would go to the very heart of the issue we said before about cybersecurity.
Well, fair enough, but if your top-level domain is more generic, in other words, if it is .phone, you would certainly want more than one bidder. You would anticipate multiple bidders for such a top-level domain, would you not? Well, and my question is, would you conduct some sort of empirical survey in advance just to be sure that there actually would be a sufficient level of competition in the bidding for administering that TLD?
One of the things we're putting forward is to have an extensive promotion of the process before it would open, so that people are aware of the process available. To come to the specific question you're asking, that we're not putting forward that we choose the string and then say who wants to bid for this. We're actually saying it's not appropriate for us to decide what string people should bid for, but the process should be open and flat, and that it's up to people who think there's an opportunity to put forward a string.
Well, the reason I'm pursuing this at some length is because the public policy justification for putting companies to the additional cost associated with protecting their brand that will come from them having to acquire buffers around that brand, not under just the existing TLDs, but potentially multiple new TLDs as well, is the new competition that comes and the choice that comes from that. And if you really don't get a level of competition in the bidding for those TLDs, then that public policy justification seems to me to be diminished substantially. So I think it is a legitimate area. Let me ask if anyone else on the panel wants to comment on that question. Ms. Deutsch?
Yes, I would just raise, I guess, 3 points. First of all, I don't think you got a clear answer, but to our knowledge, there's never been that empirical study on the need for new TLDs. Second, we already think, there are 21 gTLDs today. We think there's sufficient competition in the market today. Maybe there, could be a few more slowly released, or the international domain names might be something to think about. But 88% of all internet traffic goes to .com. That's still the premier piece of real estate. So there's nothing to say that the addition of all these new ones still won't leave .com in that dominant space. And third, we think, there is not that bidding process. It's more like speculating. People can bid, but you're not going to know who else is bidding for what name. If you happen to bid for the same name, maybe there'll be some competition.
Okay. Mr. Stearns.
Thank you, Mr. Chairman. Mr. Twomey, I think you mentioned to the gentlelady from California that you have 21 board members. How many of those are U.S. citizen? I was told by staff that 2/3 are not.
The board members are required to come from one of 5 regions in the world.
Okay.
And North America is one of those regions.
Right.
And each region has to be represented on the board,
Yeah.
as it does on each of the councils of our supporting organisations. The present number, I think, it's 7 or 8. I'll have to check
Okay.
the specific.
So roughly, I'm right. 2/3 of them are from other countries, which is, yeah. And of the 100 employees you have, how many are from the United States? Is it the same ratio, about 2/3 are from other
No,
countries?
it's much more from the United States.
Oh, okay. 50-50, you think?
It's well over 50%. It's
So
over
50% are from other
It's over
countries,
50%.
yeah. In looking through your P&L statement, just going back to this net cash reserve, you're up to about $46,425,000, and you indicated that if you go ahead with these TLDs and could generate another $90 million, so does that mean if you were $150 million in revenue that you would try to get this cash reserve up to $150 million? Was that your statement?
No, that's not the statement.
Okay.
And if I can be quite clear on the budget, the reason the budget has increased is because the very things that some of the members of the committee have raised are the concerns we have. About 20% of our budget is dedicated to security and stability issues. We've increased quite significantly our allocations to compliance work, and we are now looking at allocating more money to the compliance work. The issues with gTLD funding is that we are required by the community to be cost recovery only for that there be no cross-subsidy for anybody who's applying for new gTLD. We expect that the fees you're referring to are one-off application fees to be dealt with only in that year, and that the actual revenues would come down.
But you still indicated earlier that you want to have a reserve fund equal to your revenues.
I'm on public record of saying that should be equal to about 1 year's of the present operational basis.
Yeah, so if you're doing $61 million today, you want to do $61
It's
million
around,
in reserve.
I'm on public record as saying I think that number should be around $50 million.
So it's not what you said earlier, that it will be equivalent to 1 year's
Well,
revenue.
that was the advice we had received, but I think it should be tempted about the that period. I have to reinforce why that's important. It's important for security and stability. In the early days of ICANN, we received multiple lawsuits, which we defended quite correctly. But
Don't you have insurance to cover a lot of those multiple lawsuits?
We had some insurance, but we have no confidence that would cover all the cases.
Okay, I understand that. Ms. Alexander, I mean, frankly, they're an international organization. They don't necessarily want to be in the United States. I mean, maybe Mr. Twomey wants to take them to Australia. I mean, if they wanted to leave, what could we do to stop them? After the contract expires in September, what legal things could we do? You might not be able to answer this because you're not, I don't know. But what legal things could we do?
Thank you very much, Mr. Stearns. I think with respect to the JPA, I'm not in a position to answer those questions, but to the extent that ICANN remains the IANA functions contractor, they need to be located in the United States.
There's a legal contract. They need to be in the United States.
Yes, sir.
Okay. Now, Mr. Twomey, let's say, you wanted to be free from the contract with the Commerce Department, and you wanted to be separate and independent, and that's what you and the people would do. Would you be willing to have competition, have another agency set up and compete with you?
The functions that are being, a couple of propositions there, we are not looking to be more independent than we are now. So I want to keep reinforcing that we are an independent organisation under the law.
No, I understand.
But the actual functions in the original design work are functions that need to be centrally coordinated across a global internet. This is the allocation of this coordination of domain names and IP addressing. And in the original analysis, which was done back in the 1990s as to how to bring that forward, it was seen that they were functions in the internet that were unique, that need to be coordinated at one place. That's why the original white paper called for such an organisation, and the internet community responded to it. I think the analysis at the technical level remains that is the case. So we're very carefully structured to try to deal with many antitrust issues, and have the antitrust issues inside ICANN have been tested and tried several times in US courts, which have confirmed the model. If the technical analysis was to say that you could have multiple mechanisms of doing that coordination, then potentially, we wouldn't stand against it. But the technical analysis at the moment does not support it.
Ms. Alexander, it's my last question. This is changing the subject totally here. I'm going back to the DTV transition. About 725,000 more households have prepared themselves for the DTV transition using the stimulus money based upon the Nielsen rating data and information from the NTIA itself. At that pace, about 900,000 will have used the money to prepare by June 12th. That means we'll have spent more than $700 per household for a $50 device. Does that make sense? Assuming my mathematics is correct.
Thank you very much, Congressman. I just want to reassure you that the DTV transition is a high priority for the Secretary of Commerce.
I noticed you're reading that, so that's what they told you to tell me.
And Acting Assistant Secretary Ana Gomez. I'm not the subject matter expert on this area, and we'd be happy to provide further answers to these questions to the committee.
All right. Thank you, Mr. Chairman.
Thank you very much, Mr. Stearns. The thanks of the subcommittee to our panel of witnesses. You have been here for a long time. This has been, I think, a very interesting and informative discussion, and we appreciate your contributions to it. I'm sure that members of the subcommittee are going to have additional questions, and some members who were not able to attend the hearing today because of conflicts will also have questions. Those will be propounded to you over a period of the coming weeks, and when you receive those inquiries, to the extent that you can make rapid replies, that will be helpful to us. We're going to keep the record open from this hearing to receive those replies for a period of about 1 month, so please be prompt in getting those responses back. We appreciate very much your attendance this morning and your informative presentations, and this hearing stands adjourned.